Very excited to be here today with a great panel. We're going to be talking about developments with respect to blockchain technology and sort of talking about some recent events and using this opportunity to sort of contrast centralized versus decentralized systems utilizing blockchain technology. My name is Greg Strong. I'm going to be moderating the panel. I'm a partner at DLx Law, which is a boutique law firm in the United States with offices in New York, Wilmington, Delaware, and Washington, D.C. And I'd like to hand it over to our panelists to introduce themselves. And Melissa, maybe we can start with you.
Thank you, Greg, and thank you, Chambers. So I am Melissa Lim, and I am a partner at Walkers, and I co-head the global fintech group at Walkers. Walkers is the largest offshore firm in the world, and we practice Cayman, BVI, Bermuda, Guernsey, Jersey, and Irish laws.
Thanks very much, Melissa. And Chu, can I turn it over to you?
Sure. Thanks, Greg, and thanks everyone for inviting us. My name is Liang. I'm a director and the head of the blockchain and digital assets practice at Napier. Napier is one of Singapore's largest law firms, and we're a full service practice covering all aspects, and particularly with respect to in the blockchain cryptocurrency space. We handle both regulatory and dispute matters in the space.
Thanks very much. And Ben, bring us home here.
Sure. Thanks, Greg. Nice to be here. Ben Bathgate. I'm in Toronto, Canada. Macmillan, one of Canada's national law firms, and I co-chair our fraud group and work extensively in tracing with digital assets and crypto and looking at court remedies that applies largely to that space.
All right. Well, very relevant experience for the call today, and I wanted to just take a minute before we dive into things to sort of set the stage. Over the last 6 months to a year, we've seen a lot of activity in the blockchain space. And in particular, we've seen some failures in centralized business models with a wave of bankruptcies that really was sort of predicated by the collapse of the Terra network and the Terra USD token and the Luna token. And so what followed was an insolvency of Three Arrows Capital, which was a very large hedge fund, which had some activities in Singapore, but was based outside of Singapore and in the BVI. And then some related bankruptcies with respect to Celsius here in the US, Voyager also in the US with a Canadian twist to it, FTX, BlockFi, and most recently Genesis. And so I guess sort of stepping back and looking at this generally, you know, what happened here? And maybe, Chu, if you could start us off with some thoughts generally about how we wound up in this spot.
Sure, and I think we're continuing to find out more about the web of transactions that led us to the entire wave of failures. As each liquidation proceeds and more information comes out, I think we're getting a deeper and deeper picture. I wouldn't say wider, just because it turns out that it's getting more and more complex as we see it. But the first visible event, I think, was the as Greg, as you mentioned, the collapse of the prices of the Terra Luna network, and that triggered a margin calls on Three Arrows, which, as you mentioned, was a very large hedge fund, and Three Arrows, as a very large hedge fund, had deals and was a counterparty to a multitude of other players in the crypto space. So we're discovering that with many of the large players, they have very significant interplayer deals going on with where the exposure of one triggers consequential impacts on another. So I think where we are is where we are right now. And I think we all do expect that we'll continue to be further collapses.
Yeah, thank you very much. And Ben, you mentioned that your practice is on the fraud side with respect to asset tracing and related issues. Do you have any thoughts about sort of the interconnectedness of these entities and how you would go about untangling sort of the transactions at issue here?
Yeah, I mean, it's a big question. I think with FTX specifically, and we've talked before about some of the multi-jurisdictional issues that have come up. There is certainly a bit of a black box that exists there, and that's just something we've all had to come to terms with in this market. And I think it's been interesting as we've looked at that process with FTX and seeing the insider trading, if you can even call it that, that goes on. We do start thinking more about the risks that are involved in those areas. And as we get into, we're going to get into decentralized products more later, but as we get into those kind of areas, you see a lot of compounding of the risks as well. You see collateral that's crypto, and you see all these other issues that crop up, trading upon trading and loading and loaning after trading. There's a lot of intermingling and use and reuse of a lot of these underlying assets. And I think we'll talk more about it, I think, in the next subtopic, but I think we see a lot of compounding of those risks and not a great lens into what's behind it all.
Yeah, thank you. Melissa, I don't know if you have anything to add on these points.
Yes, so I think that was a big high profile article on how Cayman was very much affected by the FTX collapse, with many Cayman creditors. I suspect that those are really the Cayman crypto funds, because Cayman has been the #1 jurisdiction for crypto funds by far, actually, based on a recent PwC report on crypto funds. And I suspect that given that the collapse of FTX only occurred in November, there probably wasn't sufficient time for any redemption notices to be submitted in time, or redemption requests to be submitted in time for December 31st. So it will be interesting to see what effect it will have on the Cayman crypto funds for the March 31st redemption date.
Yes, that will be very interesting. And so sort of jumping ahead to talk more about FTX, obviously there are a whole litany of different proceedings involving FTX. At this point, there's a bankruptcy proceeding here in Delaware, where I'm located. There is a criminal case with respect to individuals who were running FTX, or multiple criminal cases. And then there are SEC and CFTC enforcement actions in the US. Ben, I wanted to just ask you, when you have a number of different matters going on like that, does that sort of put you in a different bucket than just typically what you would see in a fraud litigation that's civil in nature only?
Yeah, I mean, it's the fight before the fight, right? And I think that's really interesting. And we saw it in the early days with FTX to the bankruptcy proceeding. I'm not a bankruptcy lawyer, but obviously working in the crypto space with tracing and fraud, I see a lot of it. And it was interesting with the FTX case, how you saw right from the get-go, the things we take for granted, like a stay under Chapter 15, even those kind of things not being something you could take for granted. I mean, it was interesting to see there how right away the Bahamian regulators, try to fight to retain some control through the liquidation process. They backed off at a certain point. The Southern District in New York obviously got involved, but you're seeing arguments right from the get-go about what was going on in the Bahamas. Rumors about Bahamian authorities encouraging Bankman-Fried and some associates to give their customers preferred treatment. I mean, what was going on there? You see a certain kind of expectation what's going to happen when you've got a Chapter 11 process in the U.S., but then you've got early days, things already starting to move and people getting certain preference allegedly. So I think, there's the fight before the fight. And I think that's an interesting one because, right away, everybody's running out to get out of the sinking ship, so to speak. And some of the things we take for granted in terms of stays and processes like that it's going to go through a regular process. You can't even take that for granted anymore.
Yeah. Very interesting. And I noted that there was a recent lawsuit filed on behalf of FTX or Alameda Research, actually, against Grayscale related to GBTC. So obviously, significant efforts being expended to try and recoup assets back into the bankruptcy estate for the benefit of creditors. And it'll be interesting to see how that lawsuit plays out from a number of different perspectives. Chua, I wanted to ask you, Melissa talked about the funds in Cayman and upcoming redemptions at the end of March. Three Arrows had some Singapore ties. Can you talk a little bit about what their activities were in Singapore and how they were regulated?
Sure. So to clarify, I think the Three Arrows fund itself, the fund entity itself, was at the BVI. The fund manager was in Singapore and licensed in Singapore. So the team, Suzu and Carl Davies, they lived in Singapore. Their office was here. Their families were here. Their homes here, and many of their investors were here. I mean, so one of the primary attractions for them to set up in Singapore is that it's a great place to access both Asian and Western investors. And the structure that they had, meaning a Singapore fund manager with the fund entity in the BVI, I think is very common among traditional fund structures. So in Singapore, they were licensed with the Monetary Authority of Singapore as a registered fund management company, and so this is the exact same license you would get as a securities fund. And so this license then allowed them to invest both in tokens as well as in the equity of companies and in securities and so forth. So that's where they were. They did get to a point where they received a reprimand from the MAS for vastly exceeding the assets under management that they were expected to have with that license. So that's one of the events that happened there.
Yeah, thank you very much. So I think we sort of mentioned the multi-jurisdictional issues in the context of FTX and a lot of these insolvencies. And, obviously, crypto assets are very easily transferable. And so this is a global phenomenon. Any thoughts from any of the panelists on any other considerations from a multi-jurisdictional perspective, given all that's going on here?
I mean, if I can continue on the Three Arrows aspect, it was fairly straightforward in that case because the fund was in BVI, and so that made a BVI bankruptcy a very logical place. And the Singapore courts very early on acknowledged the proper jurisdiction of the BVI bankruptcy courts in that. Having said that, there are several court cases that have been brought up in Singapore, which have allegations against the fund management entity, and particularly, where things weren't, certainly the allegations are that contracts were entered in the capacity of the Singapore entity and not of the fund entity. And of course, many of the team's personal assets are located in Singapore. So there's a completely parallel track to bankruptcy proceeding that's happening here as well.
Yeah, I would echo Drew, because a lot of the Cayman funds, the Cayman fund vehicle will be within Cayman, but the fund manager will be typically in the US. So definitely we deal with the multi-jurisdictional cross-border issues. Many times I've had our partners fly to the US and be the expert witness when it comes to Cayman law. So definitely we're very conscious of how important it is to ensure that we work closely with onshore lawyers, with the US lawyers on the setup of these structures and any dispute resolution of these structures.
I think as well, Greg, I mean, we talk about that sort of knock-on effect in different jurisdictions. I mean, Voyager lost a lot. It was on the Toronto Stock Exchange, and it defaulted on a loan of US $655 million. There was the whole issue coming from Three Arrows there. I mean, it lent $655 million to Three Arrows, a hedge fund that traded in crypto. There was the default then, and of course, no surprise when that took a hit with Three Arrows. Then Luna had its crash, and everything sort of had that knock-on effect. Then of course, Voyager stock plummeted, and then the investment industry regulators of Canada, IROC, come in and announced suspension of trading of Voyager. So that knock-on effect is so hard to avoid when there is this reliance and further reliance and compounding of these assets through these different platforms. And that's one of, I think, the key risk here we're seeing as fraud is multiplied upon fraud, is just, how do you get a better lens in these compounding of losses when you do have this sort of shadow banking system in the decentralized finance world? And I know we're going to get more into that, but I think that's where a lot of that risk builds and builds and builds to points that we see in these giant schemes like FTX.
Yeah, thank you. And I think that raises, the next question, which is, in your jurisdictions, how are activities involving crypto assets regulated? On the fund side, Chua, I think you mentioned that Three Arrows was registered with the Monetary Authority of Singapore. Just give us a high level, sense of what the laws are in place that regulate this type of activity.
Okay, so for Singapore, I mean, we have the traditional securities laws that apply everywhere, and as I mentioned, Three Arrows is actually licensed under the securities laws as a as a securities fund. In addition to that, Singapore also has a specific regime for digital payment tokens. So it's a specific subclass of tokens that are used for payment. So this is under the Payment Services Act, and it's a licensing regime for today for issuing the tokens and running a centralized exchange. There's also an amendment which has already been passed but is not yet in effect, which expands the scope of licensing to custody of tokens, centralized money transmission of tokens, and facilitating exchange without custody. So that's and so those all require a specific PS Act license, and those have been slowly coming out from the MAS.
Yeah, thank you very much. And Melissa, I believe the VASP law in Caymans is similar, right?
Exactly. So the Cayman introduced the Virtual Asset Services Providers Act in 2020, and in 2 phases, actually. So phase 1 relates to registration, and phase 2 relates to licensing. So any Cayman entity that engages in a public sale of tokens, or the business of exchanging, transferring, or custodying virtual assets on behalf of others, or the provision of financial services in connection with the issuance or sale of virtual assets, is required to be registered. Now, the phase 2 relates specifically to an upgrade of such registration into a license if you're dealing specifically in crypto custody or a crypto exchange or a public sale of tokens. That phase 2 is actually not in effect as yet. So right now we're just in a registration phase. And then similarly to Singapore, we have our Securities Investments Business Act as well. So if you're dealing in securities, if you're dealing in crypto derivatives, that's also considered a security, then we'll need to advise on whether that activity falls under that Securities Investments Business Act.
Great. And I think, in the US, just to speak on this quickly, we obviously have the securities laws, which, our current SEC chair would like to apply to most all digital assets. And so that is a facts and circumstances specific test to determine whether or not transactions involving those assets constitute investment contracts under the Howey test. But I think, it's definitely the view of the regulator here that that most offers and sales of digital assets would meet that test. And then I think, the other sort of guardrail is on the money transmission side of things. So registration as a money services business at the federal level, which requires Bank Secrecy Act compliance, and then registration or licensing at the state level in states in which you're going to be providing money transmission activities. And so most centralized exchanges in the US are registered as MSBs and have money transmission licenses in the states in which they're operating. But the next question really is, given all of the recent failures, what do we expect to see going forward from a regulatory perspective? Do you think there will be adjustments to these regimes or new laws passed in your jurisdictions? Chua, I guess I'll start with you. I know you mentioned that there's a custody component, and obviously, like a lot of the failed businesses here were custodying assets on behalf of customers who now cannot get them back or are standing in line with other creditors in a bankruptcy. So this is a significant focus, I think, from a U.S. perspective, and making sure that custodians of assets are clearly, setting forth the parameters and how, the arrangement is intended to work, because a typical custodian would be holding on behalf of the customer, not sort of like taking the assets onto their balance sheet and then going and doing other things with them. So I know from a U.S. perspective, custody is definitely in focus, and was wondering if the Payment Services Act is going to cover that, if it does already, or if it may in the future.
So I think for Singapore, I don't anticipate any changes in law from the events, and that's largely because the Singapore regulators were perhaps a little ahead of the curve on this. As I mentioned, the amendment to the Act to expand the scope of licensing, this was actually passed early 2021, long before this wave of contagion. So the focus on custody as the locus of regulation has been there. I think it's largely an enforcement question. I think as we've talked about, Three Arrows was already a licensed entity. Many of the exchanges that collapsed in their respective home jurisdictions were in fact licensed and regulated entities. So it's not a failure of the existence of regulation here, rather the difficulties of enforcement.
Yeah, understood. And to that point, I believe I saw an article within the last couple of days about an investigation of Terraform Labs. I don't know if you can comment on that at all, but it seems as though the Singapore authorities are pursuing something there.
I can't comment on it right now.
Gotcha. Well, I put you on the spot on that one, so apologies. Melissa, maybe we'll turn it over to you. You talked about phase 2 of the VASP law in Caymans. What will that address that isn't currently addressed in the phase 1 plan?
So the phase 2 is really the upgrade of the registration to a licensing for custody, crypto custody businesses. So crypto custodians are then required to comply with any requirements by the Cayman regulator on disclosures, on safekeeping of assets, processes and procedures, on segregation of assets, ensure that there are insurance in place, cybersecurity in place, whether there is any intention to leverage or hypothecate the assets in any way, which we know that that's become a big deal. But what is interesting is that currently there are no crypto custodians currently registered under the Cayman VASP Act. I suspect that in time that will be the case. And I think really in terms of changes to legislation, given the fact that we haven't had any Cayman entities that have been significantly affected by the collapses to date, the collapses tend to be in other jurisdictions. There is no, I suppose, pressure as such, and we don't really have, retail investors within Cayman who have been significantly affected as well, in general anyway. So Cayman continues to be very crypto friendly. The Cayman government continues to be very crypto friendly, and in fact, if there are going to be any changes in the legislation, it would be probably because of industry consultation, asking for more favorable changes rather than less favorable changes.
Great, yeah, thank you. Ben, let me turn it over to you. How do you see the custody issues impacting sort of the litigation and asset tracing activities that you're involved in?
Yeah, that's sort of the perspective I've got on is the loss holders and looking at the recovery perspective. I mean, we seem to be amazed time and time again, even with the biggest players, the lack of internal controls when it comes to the assets and how they're managed. And I think you put it well when you said, before Greg, it's not your keys, not your coins, right? The amount of control there is over that, whether it's a wallet or something more sophisticated than that. And there's even a classic case in Canada, which unfortunately put us in the limelight many years ago, of Quadriga, where it was nothing more than a Ponzi scheme, an old-fashioned fraud conducted through digital assets and a more sophisticated platform, but old-fashioned fraud. But $200 million goes missing. Mr. Cotton goes missing. And, his associates and family members kind of shrug and say, well, we don't have the key. What can we do? We can't help you, right? And leaving aside whether you believe any of that, it is a reminder, and a very expensive reminder, and we've had a few of these, as to the implications of that when you don't have insights into those internal controls that we expect with many of our intermediaries and institutions. And when you've got some of these operations which looks fairly sophisticated and large in certain respects, but have these types of very lax, simplistic internal controls, and ones that rely on a person or two people. I mean, it's outrageous considering the amounts of assets we're talking about that's what's done, but it is. So looking at from that recovery perspective, that's one side of it, and the struggles that creates for loss holders. But also, if you don't run that problem there, I look at it from the side of the core process, because sometimes if there's disputes over crypto assets, then there's a question as to a core custodian and who's going to be named and ordered to hold those. And I can tell you from experience, not easy to find, especially with some of the exotic tokens out there, not easy to find custodians that are going to stand up, ensure, protect those with Gnosis Vault or whatever they're using. Very interesting questions come up from that. I think we're still trying to figure out what the answers are.
Yeah, thank you. That's very interesting. And I think, just coming back to what we can expect from a regulatory perspective, in the US at least, I think there is an effort underway to sort of make sure that problems that may happen in the digital asset space are not somehow bleeding over into our traditional finance space. People may have been following what's going on with Silvergate and the troubles that they're having, given their relationships with a lot of customers that they had that are in the crypto space. And I think this is something that is definitely a focus in the US. And so I wanted to ask some questions about stablecoins. And Chua, maybe you can just describe for the audience, what a stablecoin is, so we can sort of set some groundwork.
Well, I think in its original iteration, the idea of a stablecoin was a token that was backed 1:1 with a fiat currency. So a US dollar coin, for instance, would be valued and redeemable and backed by $1 at an account. And of course, that then leads to open the question, well, how do you know that the dollars are really there? As the space expanded, I think you also have what we call algorithmic stable coins. So it's coins that didn't actually have dollars backing them, but instead had a design whereby by the design of the algorithm was intended to ensure that the stable coin retained a value that was equal to the value of the fiat stable coin. So Terra, for instance, was an algorithmic stablecoin. I think those are much more complicated. Those I think you'll have to consider the algorithm backing that specifically, and to see whether that algorithm makes sense and whether that structure actually makes sense, as opposed to a backed stablecoin where your question really is one of execution rather than structure.
Yeah, thank you. That's super helpful. And the reason why I'm asking about stablecoins at this point is because I think really a stablecoin is sort of provides an on-ramp to sort of like the digital economy, and people who may be interested in acquiring other assets or engaging in transactions, that are sitting on top of blockchain, will likely have stablecoins as a primary asset that they hold. And so, as we see, sort of the clamps come down to separate the digital economy from the traditional economy, I guess the question will be, are stablecoins going to be able to be used in that way going forward? And I think also there are some interesting, developments in terms of sovereign, CBDCs being looked at. And I know the MAS has an ongoing project in Singapore. So maybe, Chu, if you could talk a little bit about that.
Sure. I think for that, they're probably interrelated questions, but when we talk about central bank digital currencies, CBDCs, I think the one major split that it is important to think about is wholesale CBDCs, which are primarily intended to be used among financial institutions, and retail CBDCs. And usually when people think about CBDCs and think about both the pros and cons, they're generally thinking about retail CBDCs, where your man in the street, you and I, would hold these CBDCs and use them to buy coffee. The MAS has been for many years now experimenting and researching CBDCs. Much of that focus has been in the wholesale space. So an increase in the ability for the use of CBDCs for interbank settlement rather than retail use. Because Singapore is a very small island with a pretty advanced fiat electronic payment systems. The view was taken pretty early that it was unlikely that a retail CBDC would provide very much in the way of improvements from a retail standpoint. So going back to your question about, therefore, these tokens affecting traditional banking, I don't think that's a concern that the MAS has in Singapore, with it being limited to a wholesale CBDC.
Great. Yeah, thank you. So I want to sort of shift the conversation a little bit. We've been focusing in the beginning parts on looking at centralized entities and the regulations and laws that apply and some of the issues that have come up recently. And I think some of these failures sort of highlight this distinction between centralization and decentralization. And so a high-level question is, what does decentralization mean, and how does it come up sort of in your practices and in the legal standards in your jurisdictions? Melissa, I know that in Cayman, Cayman foundations have been an important part of the decentralization process. So can you talk a little bit about that?
Yeah, definitely. So decentralization. So for us is we work a lot on setting up Cayman foundations to act as legal wrappers to DAOs. And I think the move is, giving the DAOs the voice, right? Giving the holders of the voting tokens, the governance tokens, the ability to vote on the direction of a project or to approve grants for a relevant ecosystem. So it's all about us bringing together a community of persons with the same purpose, that is to advance that protocol. So a lot of times we have I read that there's about 7,000 DAOs in the world now, many of them without legal entities to represent them. So they
can we just set the stage? And when you say DAO, what do you mean?
Oh, sorry. I mean decentralized autonomous organization, which comprises of a community of persons that may have the same purpose on how to advance a particular project. So they would have the ability to vote on a project. So typically they would hold what we call a governance token or a voting token, which will allow them to submit proposals and discuss the relevant project on a discourse channel, and submit a proposal to advance that ecosystem on, let's say, a protocol like Snapshot, where the community will then be able to vote on that proposal. So the aim is to advance the ecosystem, whether it is the ape coin, make a DAO. So we have a lot of these DAOs in existence that really operate to further a particular ecosystem, and Make a DAO was one of the very first ones that we actually worked on. So we set up a Cayman Foundation for Make a DAO, and Make a DAO then voted on what collateral can be held, what is the size of the collateral that should be deposited for that DeFi protocol. So you might be asking, why are we imposing these legal entities for DAOs? A lot of times it's because you still need an entity to engage in real world transactions. It's well and good to say, hey, we're going to be voting on chain and everything can be done on chain. Unfortunately, not quite there yet. We still need to have an entity that can enter into services agreements, consulting agreements. We might even need a legal entity to have bank accounts, because sometimes you just need to pay for that festival, that sponsorship in fiat. And then more importantly, the number one consideration now from many of our clients is limited liability, because the Cayman Foundation company is a company and it creates that shield of limited liability for the token holders, so that if there's any actions against the DAO, then we would hope then that the action or claim will be against the foundation rather than each individual member of the community. That is, each individual member that holds tokens, that votes in that DAO.
Yeah, thank you very much, Melissa. That's very helpful. And then Ben, I wanted to turn it over to you. How do you see the concept of decentralization playing into the litigation context and some of the work you're doing?
Sure. And just to build off Melissa's point first, because I think it's important to understand the interplay between DAOs, the community itself, and aggregating interests and working together in these decentralized market platforms, but also DeFi, right? We're talking about decentralized finance, because sometimes they're kind of overlaid and we see them both cropping up together. So just to be clear, in this instance, we're talking about DAOs, those communities working together in these decentralized finance markets where you get this peer-to-peer financial services being offered, like loans or things like that, on public blockchains. And you're cutting out the institutional middleman, getting rid of the fat cat that's in the way, and having these instantaneous, sort of in the same moment, happening and not happening, depending on the outcome, financial transactions, which obviously there's a lot of purists out there which can geek out about that and love the concepts. And we've seen DAOs do some amazing things when they aggregate that power together. So that's, on one hand, very interesting to see it happening and seeing the power of that. But on the other side, we've seen extensive billions of dollars of fraud with DAOs and with DeFi platforms. And it's interesting because we start talking about, well, how does it happen and who's responsible? And that usually is when people call me, because you've got these massive transactions going on. You have a lot of anonymity, obviously, on them. And there's a lot of excitement and purist about having that kind of purchasing power. But then you sometimes have DAOs that aren't even a thing, right? They're not necessarily LLCs. Some are, some aren't. Some aren't incorporated because I think there was belief among their principals that they somehow wouldn't get liability. I'm not liable for really bad code and smart contracts in the platform if I'm not, a corporation, if I'm not formalized. So we've seen that being challenged in many respects. But then the other interesting side of it is, and again, this is from more the litigation perspective, and we've seen it with a few instances, and Mango Markets is a great example where $116 million gets drained because of bad code, and then the people who might have contributed to the bad code, the principals, come up with a settlement and a vote for the DAO on a settlement saying, well, why don't we let the bad actor who says he didn't do anything wrong, it's arbitrage, it's a commercial transaction, why don't we let him take a whole bunch of it as a bounty, and then we'll agree not to sue him, not to freeze his assets, not to get law enforcement involved, none of which you can't do that, of course, but they agreed to it anyway. And now what do we have? The Securities Commission's coming after them. You've got lawsuits coming after them. He gets, Eisenberg gets arrested in Puerto Rico because of it, and there's a criminal matter. So I think it's interesting because who gets that responsibility? Who bears that? Does a DAO vote mean you've lost your civil rights to go after them? And I think we're going to see a lot of those answers in the Mango Markets case pretty soon in New York.
Yeah, super interesting. And I think the question of where do you draw the line in terms of responsibility is sort of the big one. I wanted to talk a little bit about CFTC enforcement action involving OkiDAO and see if you guys had some thoughts there. I do think it's important to just highlight something that Ben said, which is, DAOs can be set up to run lots of different types of protocols. And so you can have a group of people that come together with a common purpose and sort of contribute their time and effort to building lots of different things. The Mango Markets protocol was a DeFi protocol. The OkiDAO protocol was also a protocol that allowed participants to engage in financial transactions that would otherwise be highly regulated if there were, if that platform was put out by a centralized entity, and that's what the CFTC case is about. So I think there is a distinction between a DAO coming together to provide what would otherwise be a regulated financial service in the US or in Canada or in any jurisdiction, and a DAO coming together to provide some other type of a service or to develop some other type of platform. But I guess the question about line drawing is when you have a loosely affiliated group of people, how do you apportion responsibility? And in the OkiDAO case, the CFTC wound up bringing an action against an unincorporated association. So I don't believe there was a legal wrapper associated with the DAO. Melissa or Chua, do you have thoughts about that?
Yes, that's right. After that CFTC action, we did receive a lot of calls from US lawyers and US clients about then putting in place a Cayman Foundation to be that legal shield, that legal wrapper for DAOs that do not have legal entities. When we're talking about existing DAOs here, not newly created DAOs, because they were very worried that the same thing will occur to them, that each holder of a voting token in the particular DAO will then be subject to any action by the CFTC in their personal capacity. I can't speak to US law, but perhaps the view was that they could even be seen as general partnerships, as in each member of the DAO is seen as a partner to each other. So we've been very busy setting up these Cayman Foundations to put in that shield, and hopefully then if there is going to be another claim in the future, that would be against the foundation and not the DAO members. But we will have to see.
Thanks very much. Chua, do you have thoughts on this?
Largely, I would echo what Melissa has said. The other thing that not having an entity creates is this vast amount of uncertainty about who is a member of the DAO, specifically if an action is taken. Given how quickly these governance tokens trade, if you've ever had the Oki token, does that make you but if you don't have them now, or if you didn't have them when the CFTC brought forth its action, did that make you a member of the DAO? So I think that there's a vast amount of uncertainty there, which I think is where I think the interposing a layer of the Cayman Foundation has been enormously helpful.
Yeah, and just on that point, while individual holders of the OkiDAO governance token were not named as defendants, the remedies request from the CFTC certainly asked that token holders who participated in governance votes, be prohibited from engaging in certain activities involving commodity derivatives for 10 years. So there could be significant consequences, and the CFTC chose to sort of draw the line, at least for the purposes of the complaint, at token holders who actively voted on governance. And whether a judge will go along with that or how that plays out as the case unfolds is another question. But at least we have a sense of where the regulator stood there. Ben, do you have thoughts?
Yeah, I just think it's an interesting comparison, because you've got the OkiDAO case where you don't have that LLC or that entity, and then you've got Mango Markets where you do, and you see differing directions in where they go. And I think very interesting questions on both sides as to the implications on who crafts the governance vote, right? Did other people have input into that governance vote? Who voted on who didn't? What was quorum for that vote? I mean, even with Mango Markets, the person who stole the tokens, he voted, right? And he had a lot of tokens to vote too. So there are some perverse results in what is a very noble and purist approach in these DAOs. But when you do put them on a protocol like DeFi, like you said, Greg, it creates some very interesting questions about what's an agreement, what is consent. And I think we have to interface these old concepts of what that means in our courts with these new instruments and how they're actually executed upon. So I think they're both going to be an interesting test case when you don't have the LLC, and one where you do, and where the courts find that consent and agreement.
Yeah, no, I think that's a great question or a great point, and I wanted to just follow up on that because you know, a lot of these protocols are, you know, just smart contracts deployed to a blockchain, and people can choose to interact with them if they want to or not. Typically, there's not sort of a legal agreement that gets entered into by participants and the protocol. So, for instance, if I went on the Mango markets and I wanted to engage in a transaction, just from a litigation perspective, do you think that there would be a legally enforceable obligation against the protocol or against the DAO with respect to my interaction with the protocol?
Well, if you come
on the traditional side, you would have some sort of an agreement where like the terms of the transaction would be set forth. I would read it or not, but I would sign it. And that would be my binding signature. If I had a problem down the road, I would look at the agreement and then I'd carry the agreement into court and I'd say, Judge, they were supposed to do X, Y, and Z. They didn't, and I suffered a loss. That's not exactly how it would work with a DeFi protocol. Just curious as to your perspectives there.
Yeah, I mean, just quickly myself before I pass it back, I think it depends if you ask the purists or not, right? Because some people say it did exactly what it was supposed to do, right? The smart contract and the code did what it was intended to do. And if you're participating on that, you should have a sufficient knowledge base and comfort level that you were able to read what that transaction, the code was to do. Now, that's extremely complicated. And obviously, they're still finding errors in some of these recycled smart contracts. So perhaps that's putting too much of an onus on a user and a trader. But I think some purists would say, you know, you got what you paid for. It just wasn't what you thought it was. I think the courts, though, you know, we'll see, but I think they're going to take more of a logical and more reasonable approach to it and saying, you know, well, could that have really been what that user or trader intended, right? That result. And there's some perverse examples like Mango Markets. How could you have intended that someone would rebalance the value of tokens, take all of them and leave you with nothing? That's hard to explain that, you know, in reasonable, rational terms, that was what you intended when you participated on this. But then it becomes a question is who's responsible for that? Is that just buyer beware, or the principals who were contributing to that code, or the originators of the code? Are they really bearing that responsibility? Because it's not what they really offered out that a reasonable person would have thought it was going to do.
Yeah, no, that's super interesting. I wish we had a little bit more time. I think we're running sort of up on the end of our time here. I wanted to give each of the panelists just a quick opportunity to share some last thoughts. So Melissa, maybe we can start with you.
Yeah, definitely. So we've talked about bankruptcies, centralization, decentralization. I would say that given that, you know, the high profile bankruptcies collapses have involved centralized entities, I would expect that decentralization will continue to be the trend.
Thanks. Chua, I see some nodding, so.
I think I would completely agree. I think that, you know, when the collapses first began, I think the narrative was you know, largely that, you know, crypto is going down, and these are problems that have to do with crypto. As things continue, I think people are examining it a little closer and identifying, exactly as Melissa has mentioned, that the crypto groups that collapsed were all these centralized entities and not the decentralized protocols. So, you know, it's important to bear in mind that decentralization isn't perfect either, as Ben mentioned. It you know, has its own a different set of risks and challenges. And so I think as we'll see the wiser regulators regulate both differently.
Yeah, thank you very much. Ben, any last thoughts?
Just agree. Decentralization is going to be, I think, a lot where the attention is going to be, and it's going to be really fascinating to see how much incorporation and traditional concepts we see built in for protections, or if the Wild West is going to continue.
All right. Well, I want to thank everybody for joining. This was a great panel. Thank you to the panelists, and thanks again to Chambers for giving us the opportunity to talk blockchain. Much appreciated.